Hey, man us outside, right now. Tommy? Come on, we need some help here. Okay, go ahead. What's state say?
So, Judge, I had first amended notice back on August 6th of 2024. Given notice of intent to enhance his punishment under 1242F.
Okay, pause right here. What you're hearing is the state's intent to enhance punishment. That means if the defendant is convicted, the prosecution wants to bump up the sentencing range because of a prior felony conviction. And yes, in Texas, they can do that even if it's not in the original indictment, as long as proper notice is given. Sneaky, strategic, or just standard? You decide.
Of the Texas Penal Code, it is my intention, if this is a guilty verdict, to read the remainder under paragraph 2 of that notice, like we would if it was a part of the indictment. And further presents that before the commission of the primary offense, the defendant was finally convicted of felony of assault of a public servant on February 7, 2017, calls number 1165 in the 21st District Court of Lee County, Texas. Gives him an opportunity to enter a plea of plea or not try.
Let's untangle this legal chess match. The defense is arguing it's unfair to spring the enhancement without a jury-ready indictment. But the prosecution's come back. Notice is notice. And the defense got it last year. So here's the question. Is that fair warning? Or procedural ambush?
I object that it's not part of the indictment, even when the indictment judge was just given notice and that, to me, that's different. It has to be put on through evidence in reference to his prior. It's not part of the indictment that was presented to the jury. Part of his record at this point.
My response to that is an indictment is just about notice.
Mm-hmm.
So if we give someone the intention that if we give them notice in this written form, it's considered proper. We do it all the time.
I understand.
Actually, it was at the time, this was at the court's behest when we tried this case first time.
What's the,
Well, we never got to that.
what's the date that you're using? Because I've got,
My file mark date for this notice was August 6th of 2024. That was me amending the prior notice because I think there was a mistake in the number of district court.
okay, this is the first amended notice of state's intent to enhance punishment.
Correct, Judge.
You've received that, discussed this with your client a year ago?
Yeah.
Okay, you're on notice.
On my notes.
And it's formally filed. I don't see where there is a formality that needs to be made where he has to plead true or untrue. I know the way we do things on the enhancements on paragraphs that enhance subsequent paragraphs to the primary charge on indictments. But the key is given fair notice and of what the state intends to prove. And at the end of the day, he can stand by the presumption of innocence, and the law states that your burden is to prove it. Even when you plead true, when a plea of true is done, supplemental evidence is made to support the plea. But the defense acknowledges you're on notice. You've been aware of this first amended notice of the state's intent to enhance punishment with a alleged prior felony of assault of a public servant on February 7th, 2017 in cause number 1165 in the 21st District Court of Lee County, Texas, which the state intends to present before the jury and presumably ask for enhancement of punishment. If the defendant is found guilty, punishment can be enhanced to no less than 15, nor more than 99 years confinement in prison or life in prison.
Yes, sir.
And defense acknowledges that notice of those allegations have been received, and you've discussed that with your client.
Here it comes. The jury's backhand. If this were a movie, this is the part where the music drops. They've got a verdict in a murder trial, and we're about to find out if the prosecution's high-stakes enhancement plan is even going to matter.
Okay. Is that true, sir? All of this, you're aware that that this prior conviction can possibly be presented before the jury, which would enhance your punishment range.
Yes, sir.
And you've discussed that with your attorney.
Yes, sir.
In the event you're found guilty, if it's not guilty, you're walking out of it.
Yes, sir.
Okay.
In theory,
In this area somewhere.
but he's got other pending charges.
Oh, that's right. We've got a couple of other indictments pending. But that would end this case if they're not guilty. All right. We've got a verdict. Let's bring the jury out and receive the verdict. Thank you. And
There it is. Guilty of murder. And just like that, we're on a collision course. With the punishment phase where that prior assault conviction could now mean life in prison. Remember, one verdict down, but the fight for sentencing has only just begun.
I'm going to ask you a couple of questions. Number one, the court has received a message from the jury that the jury has reached a verdict in this case. Is that so, sir?
Yes, sir.
Is this a unanimous verdict? That is one that is agreed upon by all members of the jury?
It is.
Do any of the jurors disagree with your four persons representations? No disagreement. It does appear to indeed be unanimous. If you would be so kind, pass the documents to the bailiff. You may be seated. I will review for proper form and publish the verdict. And the defendant shall rise. In cause number 22-39014, the state of Texas versus Stephan Rayvon Angel, we, the jury, find the defendant guilty of the offense of murder as charged in the indictment signed by the jury foreperson. The verdict is received. It is made a part of the record for all purposes. Ladies and gentlemen of the jury, at this time I have accepted your verdict finding the defendant guilty of the offense of murder as indicted in this case, and that brings us to a close of phase one of this bifurcated two-part trial. We will now proceed with the punishment phase of this trial. And once again, let me repeat, you are still under the instructions that the court has given to you up to now. Let me see lawyers, please. Thank you.
That's what Lois is here.
Yeah, I see. Hey, get us outside, right now. Tommy? Come on, we need some help here. As the court would place in the record, within the last hour, the court received a verdict from the jury in
Wada courtroom brawl. You'd think this was a WWE taping, not a murder trial. What do you make of this? Grief-fueled chaos? Pure disrespect? Something deeper, boiling over? Sound off in the comments because this moment might have changed the judge's whole tone moving forward.
the case of Stephan Angel in a murder case, and the jury found the defendant guilty of the offense of murder as alleged in the indictment. So the court accepted the verdict and then broke for the lunch hour. And as participants and the jury and spectators were leaving the courtroom, this court saw some activity at the doorway. and I could see one or two bodies, and it was obvious that physical confrontation was going on at the doorway, inside the doorway, and at the doorway of this courtroom, as the court was still in session on this matter. I've reviewed a video because we've got videos everywhere, and I see three people flailing, punching at each other at the doorway of this courtroom and breaking some of the chairs outside, but it was a free-for-all fist fight going on. Y'all three, I recognize all three of you. This is a court of justice, a courthouse of justice, of honor. This is the last thing that should ever happen in this building, because we're trying to resolve problems in a humane and dignified and educated and advanced method. We're not cavemen, although you three acted like it, like we were back in the caves again, without any rules, without any sense of respect for each other. The proceedings moved forward in due process. The jury had their job, the attorneys had their job, and then we went through the penal code, the code of criminal procedure, and the rules of evidence to get to a disposition in this case, like we do in every case, using the rule of law, not fist fighting in front of the public. Can you imagine if this is what we did normally? We don't really need a building. We just meet and punch it out. We're not cavemen. We're supposed to be advanced thinkers. But not everybody thinks advanced thought. That's foolish. That was foolish. And I see assaults. Now, I understand that no one wants to press charges against anybody. But let me tell you this, I'm pressing the charges. You do it at the door of my courtroom while in session, you're going to get held in contempt of court. All three of you are charged with contempt of court. Carries with it up to 60 days in jail, 180 days in jail, 6 months. 6 months. And don't think I won't set an example, because this isn't going to be the kind of activity that decent, law-abiding, advanced human thought in America is supposed to be about. And it'll be made an example out of. And we got the video, and it didn't happen exactly in my presence. So it's going to be what's called constructive contempt. It still happened over this court's.
The judge just pulled out the Constitution and slammed it down like a mic drop. And honestly, he's not wrong. This isn't just about contempt. It's about sending a message. If we don't respect the process, what's left but fists and fury?
Authority and power at the door of its courtroom while in session, which means I can't hold a hearing right now. But what I'm going to do is you're all arrested. You're going to go to jail, and we'll bring you back, and we'll have hearings on each of these cases, and I'll get to make the determination up to 6 months in the county jail. And don't you think I won't make an example? Because this isn't the kind of behavior which you can do and then walk away from it as though nothing happened. We're supposed to set examples of behavior for all of us. And some of these cases have terrible situations. I presided over the James Byrd murder cases. I was one of the prosecutors. You don't think that was hostile? Because there were a lot of folks who felt like justice needed to be served in different ways. But we did the rule of law. The rule of law worked. Those people were prosecuted and then executed for what they did. You don't think that the experience and the sacrifices that we put in to see humanitarian ways of doing justice and the rule of law and due process works? Or is there another way? No, it worked so that the people knew that this Constitution, the flag, and the rules in the Constitution are something to be honored. That we handle our problems in a disciplined, mature, advanced method so that we are the example for the rest of the world. But that's not the way that worked out there in that doorway. All y'all did was that acted like the kids do at school grounds before we learned and get educated, duking it out there in front of everybody. People are here to resolve their problems in an honorable, disciplined way under the rule of law. What kind of example is that set that y'all can duke it out and just flail at each other, break things, and disrupt the proceeding? Disrupted my proceeding. I had to stop the proceedings that we were conducting here to finish this. But you got my